Chris Hynes, who is on leave this week. We're doing a tripartite, wonderful legal word, webinar on management rights issues. So joining me today is Vanessa Sciortino, who, fair to say, Vanessa, has been in the industry for more than 10 years, and probably quite a few of you will have been dealt with her in her previous incarnations. So welcome, Vanessa, to your inaugural Hynes Legal webinar. And our co-promoter, co-host, it's the best way to put it, Nick, looking more professional than the lawyer without the tie, Nick Buick. So Nick's the founder of the Onsite Manager. So that's 17 odd years and going, Nick.
That's right, yep.
More than 620 resident managers are part of his portal for rentals across Australia, mate. So I suppose it's probably the biggest of its kind and almost the only one of its kind. So he's also got an enormous amount of visibility on what's going on in the management rights community. So today's webinar will be a little bit of Nick to start with, then probably Vanessa and I talking about some of the legal issues that we're seeing pop up, and close it out at 2:30. So what Annie, who's hiding behind the scenes driving this for us, because Chris would normally do it, we'll put up as a link. So what we're definitely keen to do is to continue to do these things if we can. So if there's enough people that are interested in us putting on these things more regularly with just management rights content, and we talked about one might be just dealing with Form 6 issues, and the OFT would be a cracker, please let us know. So Annie will put a link up in the comments section on this on YouTube, or you can comment live now. Happy to have topics, happy to have submissions, but I suppose starting more than anything else with what's going on, Nick, what are you seeing rental-wise? I mean, the papers are all talking about property market insanity in terms of prices. What are you seeing rental market-wise with the 600 odd managers that are part of your books, which is probably gives us more visibility with the rental market than anyone in Australia almost?
We're seeing good things, Frank. There's huge demand at the moment. I think we got around 8,500 rental inquiries this November, which obviously hasn't even finished yet. And that's compared to about 4,500 12 months ago. So there's massive demand at the moment. There's massive inquiry rates and application rates. And talking to a lot of managers, some of the biggest issues they're having is just keeping up with the volume of applications and inquiries that they're getting. So there is a lot of activity out there for rentals, and that seems to be across the board. It doesn't matter if it's a regional location or capital cities. It seems to be everywhere. There's huge demand.
So an inquiry is a genuine, I suppose you're not inquiring unless someone wants to look at the property. So so I suppose what's the most you've seen on a single one? So I pop up, a manager puts up my property as a listing. They just get swamped, do they? That's what's happening?
Yeah, that's right. Well, one manager told me she put a rental up and I think she had over 100 inquiries on it, which was staggering. I didn't check it, but that's what she told me. I'm not sure if she was exaggerating or not, but that's a huge volume. But basically, yeah, so we get inquiries, and we've got automated systems that run to try and automate that as much as possible so managers don't get swamped, so that it starts trying to book in their inspections into the manager's existing schedule, and then we try and follow up automatically with those inquiries as well, and try and get them to submit an application again automatically. So there are automated systems to try and handle it, but yeah, there is a lot of stuff going on right now, so it's good.
So, Nick, is that driving up the price then of rentals? Is there a bidding war happening?
No, it's not. So if you look at, and I've checked a bunch of different locations over the last 12 months, the median rental price is completely unchanged. In some cases, it's even gone down. So that's really odd. I would recommend that the rentals price, the asking price, should increase. And that's a good way to sort of curb the amount of inquiry that you're getting, so you're not getting inundated, and more rents are being achieved for owners. But no, across the board, and that's not just with our managers, I'm looking at the one form data. So across the board, universally, rentals prices haven't really increased in 12 months at all.
Wow, because you normally think the demand would push the prices up. I suppose, it's always interesting, one of those ones too, in terms of managers getting instructions from their clients about what they want to do and not. And I know one of the anecdotally of sort of, you get concerned clients ringing sometimes where owners are trying to dictate what the market price because they might read in Melbourne what's going on in Queensland and start saying, well, I was getting $450 a week, I now want $550, and the manager's got to manage that expectation down.
Well, these days they might get it. You know, it's
Yeah.
like I said, there's peak demand out there, so roll the dice, and you can always come down. You know what I mean? You can always ask more and drop it, but from what we're seeing, no, there's lots of opportunity.
I think one of my favourite lines is called an asking price, not a getting price, for a reason.
Yeah.
So you can always have a go at it, can't you? And I suppose like it reminds me a little bit, and Vanessa, I won't insult you by saying you were around at this time because you weren't. But in the run up to the GFC, which was 2005, I suppose, Nick, when you were starting out, we had this NRAS. Remember NRAS? The genesis for NRAS was rental demand going through the roof in, I suppose, inner suburban areas. So there was, at that stage, there was rent bidding, and they actually changed the tenancy laws at the time, or the Residential Tenancies Act, which is now no longer the act we've got, to prevent landlords from basically accepting or forcing tenants to bid against each other like they would at an auction. So you couldn't put something on at $400 a week and then go to people and say, well, you can now offer $420 and you can offer $430. So
is that still illegal?
We've got a new piece of legislation now. Great question, Nick, and you're normally supposed to give me notice of those, but anyway, we've now got the Residential Tenancies and Rooming Accommodation Act, which is a successor to the Residential Tenancies Act, and that's what was regulating tenancies at the time. From memory, I don't think it got pulled across, because when NRAS arrived and then post GFC, we didn't have the newspaper headlines like we've got today with respect to rent. But mate, I think it's really interesting that that rents aren't going up despite demand. Because I'd say certainly in terms of management rights transactions, the moment I think probably North Queensland's, like TNQ, I think it's a little bit quieter, as much as we've got a few deals going on. But down here in the southeast corner and even in Early Beach, it's been, and particularly off the plan, Vanessa.
Yeah,
just lots and lots of individual transactions. So, who knows? Interest rates. Maybe we need an economic soothsayer here to tell us where interest rates are going, because I'm sure it's all hinged off that. Okay, well, mate, I suppose it'll be really interesting to sort of follow that. Well, we will keep these up, so over the next couple of months, just to keep an eye on where the applications are. But if you're doubling applications year on year, or inquiries from 4,000 to 8,500, that's extraordinary. And I suppose one of the other things, our borders open, was it the 17th of December? So perhaps, do you think some of it could be tied to that, Nick?
That's gonna be really interesting, because then you're going to have the same issue that you've got with the housing market with Southerners migrating. We're going to see that with rentals as well. So if anything, it's going to increase the demand even further. But I don't know, December's always a quiet, sort of seasonally quiet. January is normally when things go berserk. So yeah, I guess that's when we'll get a real picture of what 2022 is going to be like.
Yes, well, crystal ball's out. Right, well, there you go. So there's the state of the rental market from the guy who's probably got more visibility on it than anyone else in the management rights market, with 600 odd resident managers on his books. So that's as good an indicator as any. So hopefully most people watching that are in the letting side of management rights knocked off their feet in a rush, because I think it's probably better than the alternative, isn't it? As we say. Now, we're going to move on to, I suppose, a topic on which Vanessa and I are in furious agreement. So clawbacks. So I suppose for those of you that are in management rights, probably a little bit of background is, when you buy a management rights business off the plan, we're negotiating these at the moment, you've got an element of the business that you've got certainty around, that you're going to get, which is the caretaking side. And then you've got an element that's uncertain, which is the letting side. So, and usually the way you structure off the plan deals is you pay X dollars. There's a number of different ways to do this, I suppose, Vanessa, but the vanilla one, X dollars for the caretaking, because you're getting it, and X dollars for each letting appointment that comes in. So that's accepted off the plan. But what we're definitely starting to see is more, we call them clawbacks, but they're really price adjustment mechanisms in contracts to deal with changes in the letting pool between when the contract's signed and when the business is actually settled. So I suppose I should stop talking for a little bit, Vanessa, and might throw to you in terms of to take the lead on what we think of clawbacks.
Well, we can simply say we don't like them.
Yep.
Not in an established business. I mean, the nature of management rights is that it fluctuates. You'll lose an appointment, you'll gain an appointment, and that continues to happen. So this has kind of come about because some of the buyers wanted a little bit more certainty about what would happen if they were to sign a contract, and then a huge number of appointments were lost between the contract date and settlement. It generally doesn't happen like that. We don't lose that many appointments really to warrant every single contract, including clawback conditions, as a standard practice. That's come about because of certain lawyers in the industry who have taken it upon themselves to pretty much put them into every contract. The problem with that is when you're acting for a seller, if a seller sees that there's a clawback, so if they lose any, then their price drops, then they'll also want to be paid more if they were to gain any more appointments. And a buyer often doesn't like that, with the argument that a financier won't be able to finance that additional amount, which I don't agree with that view necessarily.
Well, it's having your cake and eating it too, isn't it? You know, you
Absolutely.
you can't have, like, it's sort of commercially unfair to say I want the price to go down, but I'm not willing for it to go up on the exact same basis on which I'm going to require it to go down.
Yeah. So the way we get around it often is to put a certain amount of number of appointments that need to be lost or gained before that clause will kick in. So it's normally 2 or more. I can't recall ever having to use that clause. Maybe once in the past 3 years that we've been putting those in, and probably more recently is with the end of the NRAS and appointments coming out of that security with the NRAS scheme. So as soon as they've ended, we've seen a lot of people just selling off their units and moving on. So that is a real concern for anyone that's buying into a complex that had NRAS and they're coming up to the end of their 10-year period.
And that was always the concern, wasn't it? NRAS period for a decade. And of course, that's only a small number of businesses. And I think probably the other thing for me, I suppose, with respect to those that advocate for them automatically, is that it's lawyers shouldn't be doing price. Agents do price, clients do price, valuers do price, lawyers shouldn't do price. So automatically thrusting, a price you're not aware of the commercial drivers behind the deal is dangerous. Because, I suppose,
Absolutely.
If I'm going to pay 8 times for something at rockstar numbers, then maybe that might justify some sort of price adjustment mechanism if the basis for that income disappears between when I buy and when I sell, or when I contract and when I sell. But if I'm paying 2 times for the business, then that's probably part of the risk that you assume in terms of buying it at a discount. So it's not this automatic nature. So I think it's still, I suppose you'd say it's probably about 2 years or so, 2 or 3 years. We've sort of seen them appear automatically, and it's not just the fait accompli that I think some people automatically throw them into, because it is a way to adjust the price. And certainly from a seller's perspective, I've had the conversations with clients where, it gets crossed the line on figures, and then we get 28 days later and we have legal due diligence and a clawback provision gets produced as part of that. And my client's saying to me, well, Frank, if I knew that was going to potentially be on the table, I wouldn't have accepted that offer, and I would have priced, and if I had, I would have priced the deal differently. So it's one of those things. So
yes.
I think,
I've also noticed, Frank, I'm not sure if you have that in those clawback conditions where we would reference that if the appointments hadn't been or hadn't changed or no issues were raised during income verification, that's what the number is. But I've seen sneaking in there is income verification or the due diligence condition. So it's giving the buyers that extra time to then decide whether or not they're going to raise any issues, which again is not necessarily correct, because income verification is where we deal with the letting appointments and any price issues, not during due diligence. The due diligence is for us as the lawyers to go through the agreements and check their validity, not to raise any issues with price.
Yeah, it's interesting. I suppose this is one of the reasons why you use experienced people to negotiate these things, because they're really important to get the contract right at the start, because this is where all this is dealt with. So I suppose that's something that probably isn't going away anytime soon. The other thing that's not going away is bodies corporate taking consideration of assignments a hell of a lot more seriously than they ever have. And Vanessa, I'm going to show my age again. So I'm going to. This is good. Lack of hair does it, Nick. You're washed the grey out, which is great. Way back in the day, the way to get a resident letting agent's license was to go to OFT and tick a yes or no to a whole bunch of questions. That was it. There was no 6 modules. There was no qualified trading. None of that. It was just extraordinary. And bodies corporates used to just simply send out a vote outside committee if they even got, and most of them wouldn't get legal advice. And so you just these things were just flying through. But now I suppose assignments from a body corporate perspective are treated, to be fair, probably with the seriousness that they do deserve, because certainly back 20 years ago they weren't. Now they definitely are. Some you could argue might go a little bit further than they should, but then that's probably a consequence, usually in my experience, of that committee not having a particularly joyful experience with their current manager. So so I think probably might be interesting to talk about now what, because we I suppose we act for anyone who'll pay us, because that's the mercenaries that we are, but we'll act for bodies corporates, we'll act for buyers, we'll act for sellers. So we see assignments from all sides of the fence. So I think, Vanessa, again, from a seller's perspective, what do you reckon is the best way to approach it?
Look, making sure that you've got the right buyer is probably the most important thing, and that they're prepared. A lot of them, we're seeing that they come to an interview having not even read an agreement, not knowing what bylaws are. So these, really simple fundamental issues aren't being properly considered, which then puts the body corporate on notice that, well, we've got a problem here because these people haven't actually read any of the agreements. So goes back all the way to the contract. When your agent presents a contract with the potential buyer, checking that they've got references and resumes, and also some references from previous people, their current committee if they're currently an owner, or others that they can then apply to the management rights business that they're looking to purchase. And obviously training is really important. There's so many training organisations now that offer services to new entrants especially, but we're even seeing that some experienced managers, they're still being asked to perform or undertake these trainings as well, just to ensure that they are 100% on top of what their requirements are, because some of the obligations are implied into an agreement and might not necessarily be spelt out. So it covers all of those issues. So yeah, really making sure that your buyer is up to scratch.
And it's most people as sellers legitimately get caught up in the price, and potentially in a market like this, where if you've got a high netting business only permanent Brisbane somewhere that's run really well for years, you're going to have a queue of buyers waiting to knock you out in terms of price. I had probably actually one of the most sophisticated management rights clients I've ever dealt with. He would not sign a contract unless he had in front of him all of the buyer's material that they were going to give to the body corporate. So it's fine for agents to bring him offers, but do not dare bring me an offer without that material, because if they're not going to stack up, I'm not going to do the deal with them, because it's not going to happen. So I think because there's nothing worse than getting to the death of a deal and having the body corporate kick up a stink about the qualifications of the buyer.
Yeah,
And
absolutely.
delay settlement, we're ready to move out and all that sort of stuff. I mean, yeah. And I think from a buyer's side, even though, say to buyer clients, even though it's not an interview in the sense of there's 15 applicants and the body corporate can pick and choose who they want, you've still got to treat it like one.
Yeah.
You one chance to make a first impression, make a really, really good one. And I think like we're all advocates for ARAMA. So ARAMA has a really good induction training program. I suppose, unfortunately, I don't speak at all of them. I get a few of them. So you might see other lawyers there. Not that I want to promote our business to them, but ARAMA has a really good induction training program. So what we'll do is put up the link to that in the comments. And even if you're an existing manager, it's worth going along, because there's not a client that I've had that's gone to that as an existing manager that hasn't got something out of it.
I've even done the course.
There you go. So if someone's been in the industry for a decade is doing it, then makes sense to do it. You just never know what you'll get out of things. And I think probably the other way to do it is to put, almost as a seller, put yourself in the shoes of the committee and say, if I put this buyer before them, how's it going to go? Now, that's not necessarily going to be the legal answer of they can't consent and all that sort of stuff. It really is, how is my committee going to react to this person? And you've got to then make an informed decision from there. And I suppose, Nick, it's an interesting one for you, like obviously with hundreds of managers on your books and being in the industry forever, where do you reckon the sophistication or quality of the people you're dealing with is compared to years gone by?
Vastly improved. Vastly. I see things, particularly in the level of marketing that's being done by managers these days. Back in the day, it was an old A-frame sign out the front, and that was literally the extent of it. These days, they're a lot more savvy. They do have a lot more training. They have staff working under them. Often they'll syndicate and own multiple complexes, so they need to have people working for them. I just see a lot more sophistication in modern managers, and it probably does have a lot to do with the extra training requirements that are being placed on them by committees and groups like ARAMA driving that forward. But it's definitely working,
Because CPD is coming for all real estate agents, and that'll include resident letting agents, and lots of managers have full licenses, which obviously means the same thing. So they can only improve the industry, I suppose. And then, mate, the last one, I was going to say, and it's probably more a question for Vanessa, and I've always used the phrase separating your lot from your management rights business, but amongst many things Vanessa has already taught me, amongst that white suits me better than any other colour, is unlinking is probably the right way to put it. So the traditional management rights business was a unit and a business, and we're seeing more and more business only businesses, and I suppose that's sort of part of your syndication, Nick. If you're not buying a unit with everyone, you can buy 3 or 4 and get some economies of scale and run that way. I suppose, Vanessa, you've seen as many of these as I have. What do you reckon?
Absolutely. Yeah. And, they bolt them on to existing businesses, which makes it easier to run for them as well. But definitely the unlinking has become much more common, a common inquiry that we're getting from existing managers to undertake that, because then if they want to sell, and it all comes back to selling, especially now when you've got the unit prices that are going up so much, especially in the likes of Noosa and other places up north. The value of the unit is much higher now than the value of the business, so it doesn't make sense for them to try to sell both of them together. So they're trying to unlink them so that they've got a saleable asset with the business. So it's easier to do that. We have an issue then with the committees because they go back to, but we're paying for an on-site manager, not realising that that's not where they're paying for their manager with the caretaking duties. And it's really the letting side of things that they get muddled up with there. And then really it's explaining to them what it means to unlink the business and the requirement just to reside on site, because nothing changes in terms of still having to perform the duties for the caretaking and even being there for the letting. And a lot of agreements have specific office hours, so they still need to comply with all of those obligations in any event. It's just about whether you live there or not.
One of the big ones that I've always had to deal with when you're talking about changing or removing an obligation to reside on site is what happens in the event of an emergency. Well, and that's that immediate take that, leaving aside, I'm yet to see a management rights agreement that says that the manager must be there to deal with fires, domestic disturbances, people having heart attacks, letting ambulances in and stuff like that. It's sort of that, there's an educative component with the committee in the sense of what the duties actually relate to and how you can allay their concerns. Because if there's a fire, anyone's capable of ringing QFES. And in fact, even
pulling the fire alarm.
Yep, absolutely. It's not just the resident manager's job to do it. And in fact, it's not even their job to do it. That's just sort of a community thing. And then I suppose if you are looking at unlinking, varying the agreements is one part of the equation. The other is actually dealing with what the bylaws say, because the bylaws quite often protect the right of a particular unit to be used for that letting purpose. So if you're actually not going to own that unit, you need to make sure that's dealt with it properly as well. So there's an article that Anil put up that we wrote about that twice now. So, but yeah, I think it's, I think probably more than anything else, it's seen more of it on the North Coast, particularly around the Noosa, because the property prices up there have gone ballistic. And it becomes a financing thing. If you've gone, you can't, a business netting $150,000 with $1 million unit attached to it just isn't going to be bankable unless you're a very, very rare breed of buyer. And I suppose then, probably last but not least, because the whole world revolves around money, finance. It's had my first conversation this time of year where we're still signing contracts. It's like, are we going to get unconditional before Christmas? No. We'll get figures done. Legal due diligence, yes, but banking, finance, absolutely not. It's just the banks are all under the pump. So now it's sort of mid-January for finance or later, but back way, I am really making myself sound like an old man here. Way back in the day, it used to be the standard contract timing was 14 days for figures, 21 for legals, 28 for finance. And invariably you'd hit those. And maybe it's post-Royal Commission, all that sort of stuff. Now it's sort of 14 or 21 for figures. And I suppose if we're going to see a deal die, it's usually going to be on figures. 28 for legals, because no one wants to spend the money on getting the legal stuff done until the figures are out of the way. And then 35, 42, 48 days for finance,
60.
subject to what's going on, what the buyer's putting up as security. The banks are, and I suppose that's not being critical of our financier friends that might be watching this, because they're under the pump. And the Royal Commission has made going through buyers' bona fides and the proper finance process ridiculously difficult. So,
And we also need to remind people that the banks don't actually start doing any of their application process until they've received the income verification report and the due diligence report. So although we say 60 days from the contract date, it's often takes them much longer because they're not starting it until we've satisfied those two conditions. So that's why we get added time at the end, and the request for finance extensions often is because of that.
Yeah. And I suppose that's one of those things. It's sort of 2 months, and then you want to add on another 30 days for your body corporate. So there's a 3-month deal. And if you've got a difficult relationship from a seller's perspective with your body corporate, or the buyer's not qualified, or there might be some issues with the assignment, then 30 days might not be enough either. So it's a common theme. Every year it seems to get more difficult. I don't know whether that is the case or whether it's always, it's a very rare deal that goes through without some scarring along the way from something going wrong. So it's just a question of where. But again, I suppose that's what we're here for, to guide people through it. So, so that, ladies and gentlemen. Okay, there you go. So we do have a question. So I'm glad Mandy's given us some feedback, which is great. Gay, thank you for your comment. So if a body corporate's unhappy with the developer's engagement, what path is there to improve the relationship between them? First thing is there's a statutory right of review there within a very limited period from both sides in relation to a developer engagement. We get this a lot, particularly on the lot owner side, where people buy a unit and suddenly realise they're lumbered with a 10 or a 25-year management rights agreement, and that will have been disclosed to them up front. And that's certainly what the Strata Title Law Reform Working Group is going through now in terms of disclosure and talking about what should and shouldn't happen, all that sort of thing. But I think for me, Gay, the starting point is actually having a relationship. It's communication. Like dead set, these businesses, and I was talking to a new client the other night, is that he's buying one that's a little bit distressed, you'd call it. I reckon 95% of the issues we get in management rights come from relationships not being formed or relationships breaking. So
absolutely,
and that starts with communication. So it's not just the whole, I've read my agreement. It's sort of engaging with them about what the expectations are, because that's another big part of it. Because if it says mow the lawn when, how, to what standard? And some people are trying to get the whole industry to a particular standard. I think that's a bit of a pipe dream. But to me, communication is the bulk of it. Some people won't communicate, but that's definitely where you have to start. I don't know, Vanessa and Nick, in your experience?
Yeah, absolutely. Getting in a room and having a chat about things or doing a walk around, because oftentimes it comes down to the misunderstanding between the agreement and what the manager's actually doing. Lot owners generally aren't there all day, every day, so they're not seeing what a manager is actually doing. And they might just be going, oh, they're doing nothing, because they can't actually see what's happening. So it's really important that, we do have that face-to-face discussion, so we can talk about whatever issues, perceived or real, there are.
Absolutely. And that, ladies and gentlemen, gets us to 2:30. So trying to keep things prompt. Well, there's sort of Vanessa and Nick, just like having a chat over a coffee, which is what this was. So what I would say to everyone is thank you very much for joining us. I've got no visibility on the numbers, but I hope there's a few of you out there, because we're talking at screens. And if you've got our emails, or like I said, pop a comment on the YouTube channel about things you might want to hear about, and we'll continue these. So Vanessa, thank you and welcome.
Thank you.
You did really well for your first one.
Thank you.
And Nick, the eternal marketer, thank you, mate.
Thanks a lot. Thanks, Greg.
Thank you.